Hi, I'm Mike Devlin, and this is Opening the Door to Family Law. And as you'll see, I've opened the door to my house and we're in the kitchen. This is where we look at the nuts and bolts of the family justice system, and we do that through the eyes of various people who are involved. Today, I'm absolutely delighted that I have a fantastic guest, Margaret DeHaas. Margaret has recently retired as the designated family judge for Liverpool and Chester, following a stellar career as a barrister, starting in London, specialising in personal injury work, where she had a massive insurance practice, until a random question from her clerk, who asked her whether she would be interested in doing some wardship cases for local authorities in the area. It was the sort of question that was put to her partly because of her talent and partly, as we'll hear from her in a moment, because she was a woman. Anyway, that was the start of an incredible journey which led her to becoming Queen's Counsel, an assistant recorder, a recorder, and then a circuit judge, specialising for most of the time in family law, but also in personal injury cases and medical negligence cases. Now, it's not that she was simply a specialist barrister, because with her husband Ian, she started publishing in this field in 1988. And I noticed that in March of this year, the Personal Injury Service, published by Butterworths, is still going. And Margaret, you can buy that at the knockdown price of £2,254, although reassuringly it is available on a pay-as-you-go method. So Margaret, I'm delighted to have you here to open the door to family law. And I think it might be interesting for people, before we start to get into the nuts and bolts of the family justice system, for you to describe how we met.
Right. Well, that takes us back not a few centuries, but certainly a few decades, Mike. As I recall, Mike was involved in a case where I was instructed by the local authority, and I think Mike was for one of the parents. And I got to court, and Mike was a solicitor, which was pretty unusual in those days, having a solicitor represent one of the parents. It struck me immediately that this man was rather too skilled for me. He knew a lot about the case, he knew a lot about the law, and he seemed to be getting on very well with the judge. And I somewhat cheekily asked him, as a solicitor, what qualifications he had to be here.
And I think,
and that was a start of a great friendship.
It was. I think just to explain for our audience, in those days, the bench where the advocates stood and sat was divided into 3 rows. Row 1 was for Queen's Counsel, row 2 for members of the junior bar, and row 3 for the humble solicitors.
That's right.
And your question to me, was I qualified, was essentially telling me to get back in my place.
We started off on a very, very jolly beginnings, and our friendship grew. My respect for you, of course, grew as the case unravelled. And I remember, Mike, that every day you wore the same tie. And so to rile you further, I actually said to you, Mike, do you have more than one tie in your possession? The answer was no. So I'm afraid I stole, is the only way I can put it this way, one of my husband's ties. And the following day I gave it as a presentation gift for you.
Yes, or wrapped up very neatly in brown paper.
Correct.
And
Absolutely.
I think It was a very precious tie to your husband because it was his old school tie.
Yes, there we go. Well, it had to be something appropriate,
Yes.
so that was it.
Yeah, so we started off in a slightly combative way.
Correct.
But in the greatest traditions of advocacy, it was a hard-fought case.
Yes.
And by the end of the week, and I won't say who came out on top, but
I prefer not to remember.
a really true friendship had developed.
Yes, I think, Mike, that's something that people obviously don't understand, because in court, the advocates, whether they're solicitors or barristers, have a very professional relationship. We argue our case. We stand up for what our client's case is. We stand up to what we believe is right to convey to the court. We stand up to the judge because one has to be fearless. But once the case is over, we shake hands and we move on to the next case.
Yeah.
And there is no bitterness, there's no hostility. It's part of your professional duty to get on with the opposing advocate, but to stand up for your case.
Yeah.
And to stand up for your client.
I touched upon, in a slightly humorous way, how you became involved in the family justice system, but can you just explain or go into a little bit more detail how it became such an important part of your career and also your life?
Yes, sure. Well, I started off in defence insurance chambers in London. I was given the opportunity to get into the family justice system through the wardship cases. And I think what I learned very, very quickly was I was involved in a part of the justice system which really matters: the future of children. Because if you can make a difference to the future of children, what greater contribution is there? Whether it be as an advocate or as a CAFCAS officer, a social worker, a judge, whatever. Getting the right answer, what's in the best interests of a child, if you have a contribution to that, it's very fulfilling.
Yes, yeah. You can change lives.
You can change lives, and you can be an important contributor to that.
Yeah.
Yes.
As a barrister, what were the best and what were the worst parts of the system from your experience?
Yeah. As a barrister and as a judge, the best parts are the other professionals who, generally speaking, have real integrity. They're dedicated. By the nature of the work, they're dedicated and they care. They really do their best in very stressful circumstances. This is not easy work. This is very stressful work. You're dealing with people's emotions. You're dealing with what really matters: family life, relationships, those who are dear to them, sometimes those who aren't so dear to them. And it's about managing those emotions. It's a real pleasure to meet other professionals who have a value system and to work with those professionals. Yeah. But the worst parts, I think, are when they're not supported, and particularly where you have very difficult, very stressful cases, tense cases, where they don't have legal aid, they don't have legal advice. So there's no one to manage their expectation. And in that situation, people erupt. They erupt emotionally. Sometimes they erupt physically. And you have to be able to cope with that.
Yeah.
This is a difficult area of the law.
Yeah.
Because you're dealing with human beings and relationships.
When you say the other professionals involved,
yes,
both you and I have experienced that, because there is such a range of people become involved, especially in cases involving children, and particularly cases where children have either been hurt or abused, because yes, people will know, well, social workers are involved. And we all know how difficult that job is. And of course, there is the CAFCAS officers, the court-appointed social workers.
Yes.
But we also deal with so many medical professionals,
Absolutely.
Psychiatric professionals, psychological professionals. Even in some cases, we have engineers explaining, of course, how mechanical forces can impact.
Correct.
Can you think of some of the cases where you've had that type of multidisciplinary involvement.
Yes. Mike, we're very lucky in our family justice system because we are assisted by a range of experts who also are terribly dedicated to the system. For example, if you have a case where a child is injured, the first thing, of course, is the child goes to hospital. So you will have the treating doctor, the treating nurses, the triage nurse. The mother or the father might have taken that child to hospital and given a history. You'll want to know what that history was. So you'll want to hear from the clinicians. And then, of course, if there's been a professionals meeting and there's a decision from the doctors that this may be a non-accidental injury, you might want to go to a medical expert. So you might have an orthopedic surgeon, for example, a pediatric orthopedic surgeon, who will have seen this child's injuries. You might have a radiologist who's taken x-rays, scans of the child's injuries. So you have independent experts. You might have one or more. You might have the parents giving an explanation as to how this accident has happened. And you might want an engineer or somebody like that to say whether or not the accident could have caused the injuries in this way, and the doctors to comment on that, talking about the range of force which the parent has explained. After that, you will have somebody from the Child and Family Services, CAFCAS, looking at what the facts are and giving you an opinion as to what's in the child's best interest. That's the acid test, what's in a child's best interest. After that, you might in fact have issues as to a mother or father's mental health. You might need a psychiatrist or a psychologist. That gives you an idea as to how many experts can get involved in one case.
One case. And of course, a parent may believe that the expert is the person who's going to decide the case. Would you like to comment on that?
Absolutely, Mike. Absolutely, yes. People often think that it is the Child and Family Services who decide a case. They do a report for the court, representing as they do the child. The expert does a report on what, in his opinion or her opinion, may have happened, or what are the likely explanations for a child's injuries. But the task for a judge is not that the expert decides the case, or CAFCAS decides the case, or the social worker decides the case. Far from it. The judge essentially is presented with various parts of a jigsaw. There's the parents giving evidence, the witnesses giving evidence, the experts giving evidence, CAFCAS, the social worker. And our job is to look at all the evidence as you would in a jigsaw, all the various pieces, fit together those pieces and ask yourself, having regard to all those pieces of evidence, what is the likely scenario in this case? And analyse it accordingly.
And of course, that's such an important word, isn't it? Likely.
Yes. On the balance of probabilities, more likely than not. What has happened? More likely than not. What's in the best interest of the child? More likely than not.
Very often when dealing with a lay person, a lay client, and I'm sure this will have happened to you, they seem to become focused on whether the judge likes them or not, or whether the judge likes the other party, the husband or the wife likes them more than them. As a human being, it must be difficult to avoid having a preference, because sometimes you can have people who are very pleasant, very attractive personalities, and others who are not.
Yes, absolutely.
Right. How do you deal with that situation?
You get the awkward, you get the pleasant, you get the charming, you get everybody. As a judge, you have to be very aware of your judicial persona. And when you go for an interview as a judge, they actually ask you, do you have any prejudices? And the person who says no, well, that's unbelievable, because people have prejudices.
Of course.
The important thing, of course, is to be aware of your prejudices and to deal with them and counter them.
Yeah.
But when you're a judge, it's always best to sit poker-faced and not let charm oversway you or be charmed by it. And the similar way, awkwardness can often be a manifestation of just nerves or a perception that you're not being treated fairly. You have to be aware of that. Why is a person charming? Why is a person awkward? And your job as a judge is to analyse that and to make sure that you're treating everybody fairly and even-handedly, and justice must not only be done, but must be seen to be done. And ultimately, Mike, as a judge, you have to do the judgments. What is the fact? What are the facts? What's agreed? What's not agreed? What do you ultimately conclude? You have to explain yourself, particularly to the person who's going to lose. It's important they understand why they've lost. It's important they understand that if they've been nervous, if they've been objectionable, you actually put to paper why you think they've been that way. It might be that they've been objectionable because they're lying.
Yes.
In which case you have to say so. But it might be they're being objectionable because they simply are nervous, in which case you say so. So the important point here, Mike, is transparency. Explaining exactly what has happened, why it's happened, and why you conclude as you do.
So a message to those listening or watching here is that it's not a popularity contest.
It's not. Absolutely.
Yeah.
And judges have to explain their reasons and be absolutely transparent.
In fact...
And judges do understand people who come into court and cry.
Yeah.
Just because you come into court and, lose your equilibrium, lose your calm, doesn't mean you've lost.
Yeah.
It's a human experience, the family court. We're human beings. And that's our job, is to understand those emotions.
In fact, I'm sure you've had this experience as well. Clients sometimes get terrified, particularly as a judgment is unfolding, that the judge is going through the attributes, the positives of the person who's going to lose, and the attributes and the positives of their case. But as you said, part of the art of giving a judgment is to demonstrate that you've listened to both sides of the case.
Correct.
And you've attached equal weight to both sides, as opposed to rushing to judgment.
Correct. You have to analyse each witness and say why you believe certain parts, why you disbelieve certain parts, if that be the position. It has to be properly explained.
Yeah.
And the best advice I can give for anybody who's coming to court in a family case...
Thank you. You've brought me on to the next point there without me having to raise it. No.
But the best part is understand that the judge isn't interested in what every fact is. The judge is only going to be able to look at what is relevant and what isn't relevant. Not the whole embodiment of what you think may be relevant.
Yes.
It's for the judge to look at what the issues are and, pursuant to those issues, what are the relevant facts. And for a lay party, you have to remember that you should understand that a judge has to decide a case according to the law. So just familiarise yourself. What is the law? And the law in most children's cases is what's in the best interest of a child.
Of course.
Not what's in the best interest of the adult, what's in the best interest of the child. And for that party, understand what is the other party saying, what are they seeking, and why are they seeking that? Why are they saying something totally different? Is there any truth in what they're saying? Is there any logic in what they're saying? So try and manage your expectations by understanding what the other side of the coin is, because then you might begin to understand what is the judge's role.
Now, as a judge, you're used to giving feedback. In fact, I've been at the receiving end of some feedback. And in your time in Merseyside, which I know was a very, very important period in your career, you led from the front as a judge.
Yes.
And you weren't afraid to put people on the naughty step if they hadn't complied with directions. Because you wanted to run an efficient as well as a just court. My question is, did you ever get feedback yourself as a judge?
Well, sadly, the answer is yes and no, Mike, and I'll explain. For many years, too many years I care to remember, I was the designated family judge for Cheshire and Merseyside, which is a leadership role. And you get feedback in the context of the staff who might say, Judge, there are too many cases and there's discomfort in certain quarters that the cases aren't going fast enough, or there are too many cases, or
people aren't given enough time.
You'll get general feedback from the staff who pick up the general atmosphere, not specifics.
I don't think people appreciate just what a vital role the court staff play.
Exactly right,
the judge's clerk,
absolutely,
the ushers.
Well, you don't get advocates coming into your chambers and saying, Judge, you did a good job or you did a bad job. Nothing as direct as that. Of course, you do get feedback from the Court of Appeal. If your judgment goes on appeal, you will get feedback from the Court of Appeal in terms of their judgment, which is open and transparent, and they'll say either they upheld you or, in fact, they allowed the appeal and why they allowed the appeal. You get very...
That can be quite brutal.
That can be very brutal, absolutely.
Yeah.
Sometimes it's very nice feedback, sometimes not so nice.
Yeah.
But everything in the law is very transparent because every judgment I give is amenable to an appeal. So if somebody doesn't like it and they think I'm wrong, they can appeal it.
Yeah.
And so the feedback is formal in that respect. But the staff in the court are fantastic. And a good usher, good staff, will give you the generalised feedback as to what's going on within that court building.
Just as a matter of interest, do you think that there is a place for feedback both ways, from the advocates to the judiciary and vice versa? I know we have certain groups where in the Family Justice Council there can be feedback. But do you think that it would be helpful, or do you think it just wouldn't work in this system?
I'm somewhat concerned about that, Mike, because if there were feedback from advocates to the judge, I fear it might become too personal. One of the benefits of our system is that there's an objectivity in our relationship. And although you and I have a long-standing professional relationship, if you ever came into my court, there would be no question of my seeing you at any time in my chambers, either as a friend or as an advocate. You come into my court as a professional, and I treat you in the same way as any other advocate.
Yeah, and I can say that is exactly the case. Yeah. And in fact, even though we've known each other a long time and might see each other out of court, I've never spoken to you about any case.
No.
It wouldn't.
It would be
enter my mind and
completely wrong, completely unprofessional, and simply not allowed.
I think
so. There are very, very firm barriers, and those firm barriers, I think, are advantageous and are right.
Yes, I think people may find that slightly difficult to understand or appreciate, but as lawyers, when having grown up, with these principles etched on our heart, as it were, it's second nature.
It is second nature, and there's an important point here that if anybody perceives that there's a likely bias, they can apply for the judge to be recused.
Of course.
To stand down. And that's, again, an important protection.
Yes.
So I'm not keen on the idea of feedback from advocates to the judge or vice versa. What we do have, of course, is the judge giving a judgment, and if he or she wishes to praise the advocate in the judgment, as I often do, that is a form of feedback.
Yes.
And experts as well. We will analyse what the expert has said, and the expert will have a copy of our judgment at the end of that judgment.
And of course, I think by having a professional distance between an advocate and a judge, what it does mean is that the advocate should feel able, in open court, with their clients present, to say if they're not happy with the way that the judge is dealing with the case, and that I certainly have
Yes.
done that on a number of occasions. It's not a frequent thing.
No.
And it's not done, as it were, to grandstand in front of a client.
No.
It's where a client has genuine concerns. Then you must, without fear or favour,
Correct.
express your client's anxiety or concerns.
And I would expect an advocate to do that. The advocate is there for the client to be realistic, not as a parrot. There's nothing worse, and you see it very often in some cases, particularly where emotions run high, where the advocate is simply parroting what a client wants, what a client says. A good advocate says what the client wants, but tries to manage expectations.
Yes.
And the judge is there to be robust and fair and to say to an advocate, this is helpful or unhelpful. Because ultimately, we all have to further the interests of justice
Yes.
and decide what's in the best interest of the child.
Yes.
And there can't be any impediment to
Yes.
that. And fair, without fear or favour, you're right. That is the oath we give when we become judges.
And, of course, there are times we're dealing with the most important thing in someone's life, their
Correct.
child.
Yes.
And there are times when awkward situations arise and we have to take our courage in our hands. If the judge is going down a path that we think is wrong,
Yes.
say that. And
Absolutely.
not be afraid that judge is going to become our enemy.
Correct. And indeed, Mike, one of the good things about the family justice system is the professional who stands up and says, Judge, you are wrong in law. Or Judge, the facts do not justify you to adopt that stand. The judge is really helped by an advocate who is fearless and who is prepared to say, you are wrong, or you may be erring.
Yes. And of course, there are ways in which you can meet very difficult, sensitive
Yes.
moments like that. We don't have to be angry, just to assert yourself in
Yes.
a positive fashion,
That is
without
exactly
being
right.
insulting.
Yeah.
And
Parties must realise that judges have to be very calm, very collected. We can't rise to the bait, because in court, unless you have a calm and collected atmosphere, it's very difficult to decide a case. That doesn't mean that we don't manage emotions, but judges have to be very careful to stand back.
it wasn't always like that, Margaret, was it?
No, it wasn't always like that. No, it wasn't. But I think judges these days are trained to be very, very careful with their words, careful with emotions, and careful with the atmosphere, and to watch carefully and to try and manage not only the court, but the litigants.
Yes. You've had the privilege, and I would say that the work that we do is a privilege.
Yes, it is.
We're allowed into people's lives at a level that rarely happens.
Correct.
And you've had the privilege of doing that as a barrister and as a circuit judge, and then as a circuit judge with leadership responsibility. So
Yes.
you probably had the most difficult job in the world, managing other judges, didn't you?
Managing other judges, well, it was a pleasure and a privilege as well, generally speaking.
But the
Generally
point I was
speaking.
coming on to it is, if you could bring about changes in the system, what sort of things do you think could be changed for the better?
In the family justice system, I think giving more support to litigants who have not got the advantage of having an advisor, who can't get legal aid. Legal aid, having a legal representative is critical, because legal representatives generally manage expectations and help to bring about constructive solutions. The other thing which I'm very keen on is alternative dispute resolution.
Yeah.
And I'm very keen on what we used to call settlement conferences, whereby if there's a dispute between a mother and a father, or
this is something which you, I'm sure, would bring from your civil litigation
experience as well.
experience.
Absolutely.
Tell me how you were about to tell me how they work.
Yeah, sure. It's about parties who are in dispute with each other. It might be a local authority and mother and father, or it might be a mother and a father who are in dispute about where a child should live or with whom a child should be spending time.
And it could also be about how to split the family resources
Assets.
after a divorce.
Absolutely. But in finances, they're much further on with that.
Yeah.
They're very much further on with that. But certainly in children cases, it's about having the parties in court. And when I said to you, Michael, about managing expectations and understanding what the other party's case is, it's about the judge saying to each party, look, I've read the papers. Let's hear what you say about your case. Let's hear about what you say about your case. Hearing everybody say what needs to be said about their individual cases. And then with their consent, standing back and saying, look, this may be a realistic outcome, and I'm going to tell you why I think it's a realistic outcome. What are my reasons? And telling them what you think as a judge. Either they accept it or they reject it. If they reject it, it's a confidential analysis. It goes to another judge for the case to be decided. Yeah. But if they accept it, of course, it means there is no contested hearing. It means the matter resolves with a deal of understanding, because they now understand what is being said by the other side, what the judge's analysis is, and how the case really needs to unravel.
Yes.
They're usually represented, but they have a good understanding of the way forward without the upset, the tension, the fury of a contested hearing, and sometimes the cost.
And in a contested hearing, you each party has to make a written statement.
Yes.
And then parties actually give evidence.
Yes.
And not only do they read what the other person says about them, but then they also hear it. And once something's been written and said, it can't be unwritten and unsaid.
Correct. It usually is very corrosive of relationships.
I think that you did go through that sort of system in Liverpool when you were sitting.
Yes, we had a very good project for what we call settlement conferences, getting the parties in to try and resolve matters at an early stage. Huge success rate.
Yes. And was that taken up nationally?
In some parts of the country it was. Lord Justice Mumby, who was then President of the Family Division, he asked us to start that pilot. We did. It was adopted elsewhere. But it hasn't taken off everywhere, no. Because
one of the things that dismays people who find themselves embroiled in the family justice system is the delay.
Correct.
Cases can drag on. Well, cases involving local authorities asking to remove a child are meant to start and finish in 6 months.
Correct.
In your experience?
That's the theory.
Yeah, that's the theory.
Yes, they're having another push at trying to achieve that, resolving cases within 6 months. But there's a huge shortage of social workers. There's lengthy delays within the system, as you've pointed out. COVID hasn't helped. And it's not easy to finish within six months, although that is obviously a very desirous outcome, because children's futures are delayed.
Yeah.
And some people say justice delayed is justice denied.
Yeah.
And that's true. But if you have a settlement conference, of course, more cases in the system can be heard because they're not being contested. And people understand that, that is one of the positive outcomes.
Yeah. Do you think that there's much prospect of a government getting behind this sort of approach? Because family law seems to have gone off the agenda for the government.
Yes, it's a shame, because family law, of course, is critical to our civilization. I would hope that they will be back on the agenda, settlement conferences in whatever form. Clearly, it needs to be carefully thought through to ensure that both sides have proper legal advice and that proper processes are being fulfilled, that there's proper consent. When we were doing settlement conferences, everybody had to consent. And if they didn't agree, there was no pressure to agree. It would go off to another judge to decide the case. And whatever the judge who was doing the settlement conference had said was confidential.
Yes.
So there is that protection.
Yes. And that sort of thing does happen in finance cases.
It does. It happens absolutely with great success.
And probably the vast majority of those cases never
see the light of day.
No.
Absolutely. Absolutely. Saves a lot of money for the parties involved.
Yes.
Important.
Because, of course,
Yeah.
when we were practicing, public funding, legal aid was available, as it still is, for care cases where the
Yes.
local authority intervenes,
Yeah.
but also for private disputes between individuals over child arrangements, contact and residence, custody and access, as it used to be called.
Yeah.
But, of course, it's not available now.
And that's one of the problems.
Yeah.
Because parties come along to court, they don't understand the court process. Why should they? They've never been involved in the court process. They have not been able to familiarise themselves with the law, and if they do familiarise themselves with the law, they get very mixed up about what the law actually is. Of course, they're not lawyers. And then they come into court, and the atmosphere can be febrile.
Yes.
And they don't know what to expect. They don't know what the other side are saying. And they have no idea, frankly, as to what the outcome is going to be.
No. Now, I'd like you to talk to me about some of the most difficult decisions you've had to make as a judge, or some of the most difficult cases that you've had at the bar.
Yeah.
Are there any, and of course we're not mentioning names.
No, of course not.
We're just describing scenarios.
Absolutely. There's a confidentiality attached to all family cases.
And that comes as second nature. I think we all have a little box inside our head where we lock things away.
Yes, absolutely.
And it works in other parts of life, of course, as well. But any cases, any scenarios that come to mind when you think about those difficult decisions?
Yes, Mike. I think some of the most challenging cases are the cases where you get a mother and a father who cannot agree about, first of all, where a child should live, or if they do agree about that, what time the other party should spend with the child. So, for example, if a mother has the care of the child, how much time the father should spend with the child. And it could be the child's living with the father and it's vice versa. But let's deal with that sort of scenario. How much time should the non-custodial parent be spending with the child? And I think one of the most challenging scenarios, and unfortunately it happens all too often, is where I'm using the example of a mother, but it could equally be the father.
Yeah.
Equally. This is only by way of example. The mother has the care of the child, and, for example, she makes allegations, serious allegations, against the father's suitability to spend time with the child.
Yeah.
She may say, for example, that the father has abused the child physically or sexually or emotionally, or has neglected the child. Serious allegations can be made. And she may say that this is a father who is simply unsuitable to spend any time with the child. If the child does spend time with him, that child will suffer significant harm, and she cannot agree to it. And so she does not want the father to have any contact whatsoever.
Yeah. And of course, once that sort of allegation has been put into the ring,
Correct.
it can't be ignored, can it?
Correct, absolutely.
The court can't ignore it. The authorities may have to be notified.
Correct. You may have the involvement of a local authority. The judge's duty in those circumstances where such serious allegations are made are first of all to try those allegations. So what are the facts being alleged?
Yeah.
What does the father say about those facts? Is there any other supporting evidence? Is there any referral to a doctor, the school, social services? You might have to consider all those pieces of evidence. You then have to come to a decision based upon all the evidence. Are the allegations made out or not? On the balance of probabilities, more likely than not. And assume for the moment you decide that the allegations are not made out. Mother is lying. Could equally be the father who's lying. But say the mother is lying. And she has lied to deny the father. Her purpose is to deny the father a relationship with that child.
Yes.
And you make the findings. First of all, her allegations are made malevolently, with malice, and there's nothing in them. And the father ought to be having contact with the child. The mother then goes on to say, and unfortunately this is not uncommon, it could be the father going on to say,
Yeah.
The mother then goes on to say, no, don't agree with you. The father shouldn't have contact with the child. One of the challenging decisions for a judge in those circumstances is, how do you promote contact?
Yeah.
Do you force a child? Do you force the mother to make the child available for contact? Do you fine her? You can fine her. She's in contempt of court.
You could
Do you
even
send her to prison? Absolutely.
Yeah.
Well, what are you going to achieve by fining her, taking away the family resources, which may be limited, or sending a child to prison? Sorry, not the child, the mother to prison.
The mother or the parent. Yeah.
The mother to prison. What's going to happen to the child then? Are you going to make an order, nevertheless forcing the child? Because, of course, the child might have been told about the allegations, his or her mind poisoned against the non-custodial parent. All of these things happen in real life.
Yeah.
And ultimately, you could be left with a choice to involve the local authority, to say to the local authority, this is a child who is being harmed significantly, emotionally, psychologically, by the failure of this mother to promote contact, by the mother's poisoning of the child's mind. Local authority, you need to take some action here. The local authority may decide to take care proceedings, take the child into care, or manage this with a statutory order, supervision order.
And of course, there are two competing imperatives here.
Yes.
Number one, that a mother or a father should never be able to get away with that type of behaviour.
Correct.
But number two, if you were to, as it were, punish the parent for their behaviour by taking the child away and putting them either in care, foster care, or transferring the child to a parent who they have grown to see as a
monster.
Bad monster.
Yeah.
Is the cure, is the remedy worse than the original illness?
Correct. And that's, of course, one of the other dilemmas, one of the other challenging issues, because you have a child in the care of, let's say, a mother, as I've said, it could be a father, who is being poisoned against the non-custodial parent, who is being denied a relationship, who is in an atmosphere which is not conducive to safe nurturing, not conducive to safe development.
Yeah.
It's a harmful atmosphere.
Yes.
So ultimately, and this is where some judges ultimately get to, do you transfer that child from the mother to the father, live with the father, and give the mother supervised contact, supervised because she can't be trusted, what she's going to say to the child.
So it's such a dramatic
Yes.
Remedy for the original problem, isn't it?
Those are very challenging issues.
What sort of expert advice and guidance is available to a judge in that situation?
You would more likely than not have a psychologist dealing with what type of bond this child has with the mother, with the father, what the impact on this child would be of a transfer of residence.
Yeah.
So that you have a full picture. But as I said, it's only one part of the jigsaw.
Yeah.
The expert advises, the judge decides.
Yeah.
And that's the important part.
Yeah.
Public law, again, presents its own challenges.
Just staying with that for a moment, though, because sadly, although in the grand scheme of things, these are only a tiny fraction of cases that arise in real life, for a judge, they're not uncommon, are they?
They are not uncommon at all.
And now, parents don't have legal aid, so if they bring a case like this, they have to pay for their own representation. And if there's an expert involved, then the parents, or at least one, will have to pay for that as well. And we're talking about people spending £100,000 to resolve that sort of issue.
Yes, and Mike, if I were, again, this is the beauty of a settlement conference. If you bring parties into court and explain what is the process, the impact of the process, the cost of the process, the human cost of the process. In those cases, Mike, it is fair to say that the child will probably be represented.
Yeah.
So CAFCAS may represent or may agree to represent or may be ordered to represent the child, CAFCAS will have their own representation and take some share of the cost, or sometimes the entirety of the cost of the expert. So you do have that huge benefit of CAFCAS, which is a magnificent and very helpful organisation.
Yes. One of the difficulties in my experience of cases of this nature is that because very serious allegations have been raised, and because a judge has to be impartial and conduct a thoroughgoing inquiry without indicating one way or the other until the facts have been established, it's difficult, but you tell me if I'm wrong here, to say to the person who's making the allegations, woe betide you if I find that you've been telling lies here and maliciously and malevolently separating a child from his mother or her mother or father, because if I do make that finding, here's what may happen.
Yes.
Have you ever found yourself in a situation where you're able to say that, to give that message to a parent, or do you have to hold back?
Well, if you were doing a settlement conference, of course, you can give the pros and cons. You can say to a mother who's made such allegations, this is the result of the allegations are false. On the other hand, if the allegations are true, this is the result. You'd give the pros and the cons.
Yes.
If, however, you're the trial judge, you can, with care, because remember, you have to show and demonstrate you are not biased in any shape or form, or that you haven't predetermined the case. Cases can only be decided after all the evidence has been heard. But what you can do, where it is pretty obvious, for example, a mother's made an allegation as to child abuse, the child's been physically assaulted, but she's delayed in saying anything about this. She's not taken the child to the doctor. She's not said anything to the school. There have been no marks on the child. Where there is a complete absence of evidence to support the allegations, one can say as a judge, being very careful as to the language you use, the mother's made these allegations, I understand. The court, however, notes that there is no supportive evidence from the following: A, B, C, D, E, F, G. There may be good reason for that. There may not be good reason for that. This is something that has to be carefully considered. So as long as you use the language of openness with care, you can say what may be the weaknesses in the evidence. You can, as it were, try to concentrate minds on what are the issues, what are the weaknesses, what are the strengths.
Yes. You were going to talk
making it, of course, very clear that you haven't yet heard all the evidence, and there may be good reason for this.
Yes. You were going to talk about the public law aspect of these sorts of cases.
Yes, Mike, some of the most difficult cases are in public law, and just to explain, public law is where the local authority get involved, where social workers get involved in a family, where things are going wrong for a child, where there is a perception that the family needs support, or where the child is seen to be suffering significant harm, or as there's a risk for the child suffering significant harm. Social workers have a duty to get involved. It may be that there's a referral from the school or a doctor or some outside agency, or indeed a neighbour. And in those sort of cases, social workers generally do a very good job. A huge amount of credit needs to go to social workers, who are sometimes damned if they do and damned if they don't. It's a very difficult job. And sometimes what social workers do is try and support a family who are struggling. There may be real issues of neglect, real issues of financial deprivation, real issues of drugs or alcohol, domestic abuse. They try and support a family. That can sometimes be for months, sometimes years, but ultimately, sometimes things get to such a pitch that these children or child are suffering significant harm. And it's the gateway for the court saying, right, this is time for intervention, for social workers saying, Judge, please become involved in this, give us a statutory order. It could be an interim care order, it could be a supervision order. It may mean the social worker coming to court and saying, Judge, things have got to such a pitch here, this child is really suffering, remove the child or the children. Those are difficult decisions for judges, because all children generally want to be with their mum and dad.
Now, the gateway, as you said, that was we sometimes refer to it as the threshold criteria,
Yes.
which allows the court not to simply remove the child, but then to consider
Yes.
whether the welfare of the child determines that they have to be removed.
Correct.
Once that has happened and the child is removed, it can be very difficult for a parent to establish that they've changed sufficiently to justify the child coming back. And that brings us on to another really difficult decision for a judge: permanent removal.
Yeah.
Approving a long-term placement, an adoptive placement sometimes.
Yes.
How do you deal with that situation? Because it's so far-reaching. In fact, adoption cannot be changed, can it?
Correct.
Yes,
it's a draconian result. It's a draconian remedy and is recognised in law. We're one of the few countries, Mike, who allow adoption without consent of mum and dad.
Yeah.
When you remove a child, the parents are given a period of time to show that they have changed and can sustain that change.
Yeah.
It's not just change, but sustain change.
Yeah.
So it's a question of drugs or alcohol. Not only are they now off the drugs or the alcohol, but they can sustain that change, that they're not going to revert to what was before, requiring the child to be removed. So you can't put a child back in a situation where there's going to be significant risk. You have to show that it is safe, secure, consistent care that will be given to the child. If a parent has not changed, and it's for the local authority to demonstrate that, the burden of proof is on the local authority to say what the situation is, to prove the situation. If you have to, unfortunately, rule out the parent, then you have to consider other permanency alternatives. Are there any kinship carers? Are there any friends of the family who can look after this child for a significant period?
And that's just for the sake of people listening who are not aware, that's not just a random thing, it's a part of the process.
Absolutely. Right at the start of any process, family process, you find out who are the potential kinship carers, who are the friends who could care for this child. There has to be a nomination of those people right from the start.
And then those people will be assessed during the course of the proceedings.
There'll be a rigorous assessment of those persons to see whether or not they can provide the safe and consistent care which is required.
Yeah.
And they're at the top of the preference range. If it can be family, good, or friends, good. Yeah. There are also foster carers, local authority foster carers, who may be able to provide that care. But where you have a very young child and that child needs permanence, the family can't care for the child, there are no alternative carers. In this country, a draconian option, a remedy of the last resort, is adoption, which can provide the permanence where the child has a settled family, an alternative family, where the child can put down roots, where the child can be given care and nurturing. And it's about the child. Sometimes these children are very damaged children, and they need nurturing care. They need better than good enough care.
Yeah.
So these are very, very challenging cases.
I think it was, I can't remember the judgment, and it may well have been said on numerous occasions, but that since the abolition of the death penalty in this country, the most far-reaching order that any court can make is adoption. As you said, it's the order, an order of last resort.
Yes.
Having the power in your hands to make that sort of order must weigh heavily at times.
It does weigh heavily, and you have to, when you give a judgment in such cases, you have to remind yourself that if you are approving adoption, you've gone through all the other relevant options. What are the pros and cons of each of the relevant options? Every single option has to be explored. And only when nothing else will do That's the law.
Yeah.
Nothing else will do. This is a remedy of the last resort. Can you approve an adoption? But it is an option. Pros and cons of each option looked at. Stand back and then say, what is the option that's in the best interest of this child? Reminding yourself that adoption really is draconian.
Yeah. I wanted to raise that with you, Margaret, because there are voices that sometimes rise above the crowd and complain that we have a family justice system where children are where we have almost an epidemic of forced adoption, and children are unnecessarily snatched away from parents, and we have to take dissenting voices seriously.
Course. Absolutely.
But it's interesting to hear from you the way in which a judge approaches that decision.
Absolutely.
And the gravity and the seriousness with which it's treated.
And Mike, not only that, it's important to recognise that, and this is a personal view, you must remember that, if a judge makes an order for adoption, it's amenable, of course, to an appeal.
Of course.
Everything is amenable to appeal. You have to give a judgment which is reasoned. It's transparent. The reasoning is transparent. And then if the child has been approved for adoption, the child will ultimately be placed for adoption. At any time, the mother or the father has the right, until placement for adoption, to apply to revoke that adoption order.
Of course.
If there's been a change in circumstances, if the welfare is such as to permit them to go down that route. And even once the child is placed for adoption with the prospective adopters, when the prospective adopters ultimately apply for adoption, the mother and the father can oppose the adoption.
Yes. So Parliament has put in place checks and balances and safeguards.
Yes. Along that route, until the adoption order is made, there are opportunities to apply to revoke or to oppose the adoption order. So it doesn't just happen.
No. I think we're coming towards the conclusion here, but I'd like to ask you if there are any cases that stick in your mind, again, anonymously.
Of course.
That have, for good or bad reasons, or which have changed your outlook on life.
Yes. The accusation is often that the social worker gives a recommendation, CAFCAS gives a recommendation, and the judge just goes along with it. Well, that's not true. As I said before, the judge makes the judgment, and you have to be very careful about your reasons because they have to be transparent. And I always remember a case of a 14-year-old girl who sadly was raped, and she decided to go through with the pregnancy and have the child. She came from a family where there were many, many children, a single mother, and the mother was having difficulty bringing up her own children. Her own mother was having difficulty bringing up her own children, just about managing with some social work support. The 14-year-old wasn't doing particularly well at school and was very affected by the rape. And social services came along and said, the 14-year-old's baby, should be removed and placed with foster carers, and ultimately they were recommending adoption.
Even at that early stage?
Well, right, this is towards when the case came to be contested. Well, first of all, they recommended removal and then ultimately adoption. I didn't remove the child from the 14-year-old. CAFCAS were also recommending removal because I was impressed by this child, and she was a child, 14-year-old, who was represented, obviously, her determination to make good out of a very difficult situation. She didn't like school, but she just adored her baby.
Yeah.
She dressed this baby. She spent all her pocket money on clothes for the baby. She was reading up about baby development, and her mother was prepared to support her as best she could. She could stay at home with the mother. The mother had all her children with her. There were all sorts of aunts and uncles around, of course. It was a big family. And ours is not to social engineer.
Mm-hmm.
Ours is to decide, our job is to decide what's in the child's best interest. And this 14-year-old had a clear love, a clear bond for this child. I gave the local authority an interim care order so that they could support the child with the mother at home with the grandmother. And it proved to be a great success. The mother went to college, the grandmother stood in and helped, the aunts and uncles helped. And by the end of proceedings, the local authority was still saying, remove, this just won't last. The Kafkas, the guardian, was saying, remove, too young, too immature. And I said, no. And the mother kept the child. And a few years later, this case came back before me. Of course, I had made I'd made a supervision order, and the local authority wanted to extend the supervision order. They wanted to give continuing support, but it had been a great success. And the supervision order was extended for some 3 years, and throughout that time, it was just a success, and I was really delighted because one could see the maturation of this girl, the pride she took. She brought photographs to me for me, and she actually made me a cake, which we all had in court, which was very, very touching.
What a lovely story. Yes. And of course, that goes to the heart of one of the cardinal principles in family law, that children should be with their families.
Yes.
And taking some of the words from one of the most famous cases, no matter how rich or poor, wise or foolish.
Yes, Mr. Justice Headley.
A child
Real. Yes.
The child's place is with the family. The law can't improve on nature
absolutely,
unless that's displaced by likelihood of significant harm.
And where that happens,
reasons.
Then there has to be removal, of course.
Yes. But it often occurs to me that thinking or approaching things obviously as they see as in the child's best interests, professionals can sometimes be too quick to dismiss the benefits of growing up in the natural family, surrounded by the chaos of the natural family.
Absolutely.
And the chaotic love of the natural family.
Absolutely. And where there's an extended family, the grandmothers there, the aunts, the uncles, there's a huge advantage in a child having those extended family relationships and knowing her identity.
Yeah. Now, we can't give advice. We make it very clear we're not giving anyone any advice. But if there were any professionals, whether they're lawyers, social workers, doctors, or whoever, can you say the sort of thing that helps a judge most when they're dealing with a case, and the sort of things that are less helpful?
Right. Yeah. Well, I could give a lecture, Mike. I spent a long time at the Judicial College lecturing, so here we go. Judges need to identify what are the important, the material facts, what are the relevant facts, not the peripherals, the relevant facts. What issues have to be decided?
Yeah. I think that you're speaking about something that's very important to me.
Yes.
But I've been involved in cases, maybe come into a case towards the end, where no one's actually defined what issue is to be decided by the court. There's just an amorphous nebulous
dispute.
Blob of dispute.
Absolutely. So identify what the relevant facts are. What are the issues? What's the judge being asked to decide here? Yeah. And for the lawyer to tell the client what's realistic. What is the law? This is what's in the child's best interest. Not what you want, it's what's in the child's best interest. And to manage expectations, realistic expectation. Yeah. That's what I would expect a good lawyer to do, not to parrot what the client says, but to be a lawyer, a professional.
Yes. Margaret, thank you very much. We've been opening the door to family law. I've been opening my house to my wonderful guest, Margaret. It's been fantastic to talk these things through. I think we've got a few things that we've left unsaid, so
I'm sure
we might have we might have another episode here.
But Mike, my pleasure.
Thank you very much.
Thank you
Margaret.
very much indeed.
It's been great. Thank you.